You know that feeling where you've studied for hours and you still get the same concealed carry permit exam Texas questions wrong? Yeah, let's fix that today. Between you and me, the test isn't just about what you know, it's about how you read the traps they set. We're going to dive into the force dynamics, the signage maze, and the police interaction protocols that catch people off guard. This isn't a textbook read-through, it's the intel you need to walk in there with total confidence. Most people walk into the exam room thinking it's a common sense test. It isn't, it's a legal minefield. We're going to look at the why behind the laws, so the answers become obvious, not just memorized. Ready to get into the weeds? Okay, let's start with the heavy stuff. Why do we even have different levels of force? Because the law wants to see if you can scale your response to the threat. So watch this. In the real world, force is just about stopping a problem before it gets worse. Think of it like a firm shove to keep someone from grabbing your bag. The exam is going to try and trick you into thinking that any threat justifies pulling your piece. It doesn't. If the threat isn't lethal, your response can't be either. What I see students do is get John Wayne syndrome, where they think every trespasser is a target. Stick to the rule, force must be proportionate. Does that make sense? Now, deadly force is the nuclear option. It exists because sometimes a reasonable person would believe their life is truly on the line. Imagine someone lunging at you with a knife in a dark alley. The exam looks for keywords like imminent and death or serious bodily injury. If those aren't in the prompt, be very careful about picking the shoots option. The thing nobody tells you is that fears alone isn't enough. It has to be reasonable fear. Texas loves its property rights, but the castle doctrine is often misunderstood. It's there so you don't have to run away from your own home when an intruder breaks in. If someone is kicking in your front door at 2 a.m., the law presumes you acted reasonably. But here's the catch. The exam might ask about an intruder who is already running away with your TV. If they're retreating, the imminent threat might be gone. I've seen candidates fail because they thought the castle doctrine was a license to hunt. Right, quick note. Actually, let me back up. Texas is unique because we have specific rules for nighttime property protection. This is a classic exam trap. You can use force to protect property, but deadly force is only on the table in very specific nighttime scenarios like arson or burglary. Why? Because historically, you couldn't see if they were armed at night. On the test, look for the word nighttime specifically. If it's noon and someone steals your lawnmower, you can't just open fire. Keep it strictly to the scenario provided. Now, here's the thing about where you can carry. It's a game of signs and specific zones. Let's think about this differently. A 30.06 sign is basically a digital fence for concealed carry. If a business puts this up with the specific legal wording and 1-inch block letters, they're legally telling you no. The exam loves to ask about the specific requirements of the sign. If the letters are tiny or the wording is wrong, is it valid? Technically, no. But for the exam, if they mention a 30.06 sign, they want you to know it prohibits concealed carry. Don't overthink the font size unless the question specifically asks about sign legality. Right, quick reset. If 30.06 is for concealed, 30.07 is for open carry. It's that simple. A business might allow you to hide your gun but not show it. If you see both signs, you're totally out of luck there. On the test, pay attention to whether the person in the scenario is carrying openly or concealed. That one word changes the correct answer entirely. I see people breathe through these and mix up the numbers every single time. Now, here's the thing. This one is a big deal. If an establishment gets 51% or more of its income from alcohol for on-premises consumption, it's a hard no for carry. Think of a dive bar versus a Chili's. The bar is a 51% location, the restaurant isn't. The exam will test if you know that red sign means felony if you walk in armed. The thing to remember is the income source, not just that they serve booze. So, watch this. Schools are the ultimate no-go zones, but the exam gets tricky with campus carry. Generally, for the test, keep it simple, K through 12 is off limits. Colleges have specific rules where concealed carry might be okay in buildings, but open carry is a hard no. Also, watch out for polling places on election day or courtrooms. These are statutory bans, meaning they don't even need a sign to be illegal. If the question mentions a judge's office, your answer should involve leaving the gun in the car. Stay with me here, because how you handle a traffic stop can be the difference between a "have a nice day" and a "get out of the car." Wait. Okay. In Texas, if an officer asks for your ID and you're carrying, you have to show your LTC too. It's about transparency. Imagine you're pulled over for a tail light. You hand over your driver's license and your LTC together. You don't need to shout, "I have a GUN." That's a great way to make things tense. The exam will ask when you're required to show the license. The key phrase is when asked for identification by a peace officer or magistrate. Now, here's the thing. Can an officer take your gun during a stop? Yes, for their safety and yours. They have to give it back if you aren't being arrested, but they can hold on to it while they run your plates. The exam might ask if this violates your rights. It doesn't. It's a temporary administrative disarm. Don't argue with the officer on the side of the road. That's a trap for the real world and the test. Just know the officer has the authority to secure the weapon. What if you aren't carrying, but an officer asks for ID? Do you still have to show the LTC? Technically, the law says if you're carrying, you show it. If you aren't carrying, you don't have to, but many instructors, myself included, suggest doing it anyway to show you're a good guys in the system. However, for the exam, stick to the letter of the law. The requirement is triggered by carrying the handgun. So, watch this. This is a big one since the law changed. You can carry openly now, but it must be in a holster. The exam will ask what happens if your gun is just tucked into your waistband without a holster. That's a violation. So in that. Why? Because a holster ensures the trigger is protected and the gun is secure. Even if you have an LTC, if that gun is visible and not holstered, you're breaking the law. It's a simple point that catches people who think open carry means carry however you want. Okay, let's pivot to the house. Safe storage isn't just a suggestion in Texas, it's a liability shield. Set who's going to be an awesome day. If you remember nothing else from this section, remember THIS. You're responsible if a child under 17 gets a hold of your readily dischargeable firearm because you left it out. The law defines a child as under 17 here, which is different from some other statutes. If you leave a loaded Glock on the nightstand and the kid finds it, you're on the hook. The exam will ask about the age limit and the readily dischargeable status. If it's locked in a safe, you've done your job. Here's the exam day version. There are defenses to this, though. If the kid's supervised by an adult for hunting, or if they broke into your locked safe, you aren't liable. The exam likes to test these exceptions. It's about reasonable steps. Did you try to keep it safe? If the minor gained access through illegal entry burglary, the law doesn't punish the victim. What I see is students forgetting that legal use, like a kid defending themselves from an intruder can also be a defense. Okay, guys? Here's the scary part. Even if the cops don't charge you, the family of someone hurt by your gun can sue you. This is civil liability. The LTC exam touches on this because they want you to know that not guilties in criminal court doesn't mean not responsibles in civil court. Using your gun correctly saves your life. Storing it correctly saves your bank account. The exam might ask about the standard of proof. Remember, civil court is preponderance of evidence, not beyond a reasonable doubt. That's right, quick note. In Texas, your car is an extension of your home, but there's a catch. If you don't have an LTC, the gun must be hidden from plain view. If you do have an LTC, it can be in a holster in plain view. The exam will test this distinction. Why? Because they want to make sure you aren't leaving guns on the dashboard for everyone to see. Keep it out of sight if you're ever in doubt. It prevents theft and keeps the peace. Right, let's talk about keeping that license. It's a privilege, not a right, and the state can take it back. Oh. Let me put it another way. This is simple. Guns and booze don't mix. In Texas, carrying while intoxicated is a Class A misdemeanor. What's intoxicated? It's not just a 0.08 BAC, it's also not having the normal use of your mental or physical faculties. If you've had 2 beers and you're feeling buzzed, you're legally intoxicated for carry purposes. The exam will try to give you a specific BAC number. Don't just look for 0.08. Look for the loss of faculty's phrasing. Let me put it another way. Your LTC isn't forever. It usually lasts 4 to 5 years. The exam might ask when you need to renew it. State will usually send you a notice, but it's on you to keep your address updated. If you move and don't tell the DPS within 30 days, that's a technical violation. I've seen people lose their permits over a simple move because they forgot the paperwork. Keep your address current, or the state loses track of you. Now, here's the thing. This is an automatic disqualifier. If you're convicted of a felony, you can't have an LTC, period. But the exam might ask about deferred adjudication. For some offenses, even if the case was dismissed after probation, it might still count as a conviction for LTC eligibility for a certain period. Generally, if the question involves a felony, the answer is not eligible. The thing nobody tells you is that even some misdemeanors, like domestic violence, carry a lifetime ban. Okay? Texas wants to ensure permit holders are sound of mind. If you've been adjudicated as a mental defective or committed to a mental institution by a judge, you're out. Note the word judge. Voluntary treatment usually doesn't disqualify you, but a court order does. The exam looks for that legal distinction. It's about due process. If a court says you're a danger, the state won't give you the plastic card. Okay, buckle up. This next bit catches even experienced candidates. We're talking about the legalese that the test writers love. FEG. Here's the exam day version. This is the ghost that haunts the whole exam. A reasonable person is a hypothetical average Joe. When the jury asks, would a reasonable person have fired that shot, they're asking if your actions were normal for a sane person in that exact spot. If the exam scenario describes you shooting someone for yelling at you, ask yourself, would a reasonable person do that? The answer is almost always no. It's the ultimate yardstick for legal justification. This is a sneaky one. In Texas law, premises usually means the building or a portion of a building. It doesn't always include the parking lot or the sidewalk. So, if a sign says no guns on premises, you might still be legal in the parking lot. The exam will test if you know where the line is. If you're carrying in your car in the lot of a 30.06 sign building, you're usually fine. Move inside the doors and you're in trouble. Okay. Unlawful carrying of a weapon is the charge you get when you mess up. It covers everything from carrying while intoxicated to carrying in a prohibited place. Think of UCW as the catch-all for when you ignore the rules we've talked about. The exam might ask what the penalty is for carrying without a license in a place where you're not allowed. Usually it's a Class A misdemeanor, but it can jump to a felony in places like bars or schools. The law often requires that you knowingly violated a rule. If a 30.06 sign was hidden behind a bush and you didn't see it, did you knowingly enter? Probably not. But on the exam, if they say, the student saw the sign and entered anyway, they're establishing intent. Pay close attention to the character's mindset in the question. If they knew the rule and broke it, the answer is always going to be the most severe legal consequence. We've covered the heavy hitters, from the nuances of deadly force to the specific signs that can end your carry day. Remember, the exam is looking for you to be the reasonable person who knows the difference between a 30.06 and a 30.07. Don't let the legalese trip you up. Look for those keywords like imminent, nighttime, and premises. You've got the insider intel now, but the only way to make it stick is to see these questions in action. Quick recap. Do you remember the main idea from each chapter? If even one is fuzzy, that's the chapter to drill tonight. Free concealed carry permit exam, Texas practice tests are waiting on CCWExam.com. Like and subscribe, and I'll see you in the next video. Go get that license.